Some people walk into a courtroom like it's a formality, like the whole proceeding, the robes, the gavel, the oath, the carefully constructed machinery of law that took centuries to build, is just a minor inconvenience between them and wherever they're actually going afterward. Like the judge is a speed bump, like the jury is an audience, like the entire room exists to perform justice around them rather than deliver it to them. I've spent a long time studying the places where entitlement meets consequence, where the armor that money and status build around a person gets tested against something that doesn't care about either. And I can tell you that the courtroom is one of the last genuinely equalizing spaces left in modern life. Not because it always works, not because wealth doesn't buy better lawyers and softer landings, but because inside that room, on the record, in front of witnesses, there are still judges who haven't forgotten what the robe means. This is a story about one of those judges, and about a young man who walked into her courtroom believing, with every cell in his body, that none of it applied to him. His name was Dominic Harwell, 26 years old, the second son of Richard Harwell, who had built one of the largest private logistics and warehousing empires on the eastern seaboard over the course of 30 years. A man who had started with 2 trucks and ended up with a company valued at somewhere north of $3 billion. Richard Harwell was, by most accounts, a serious man. Driven, disciplined, occasionally ruthless in business, but with a reputation for keeping his word and demanding results from everyone around him, including his family. Dominic was not his father. That's the simplest way to put it. And the people who knew the family well said it had been obvious for years. Where Richard Harwell had built something, Dominic had inherited the benefits of it without any of the formation that building something creates. He had grown up in houses that were already paid for, in cars that arrived without effort, in a social world where his last name opened doors that most people never even see. He had attended a private university for 2 years before withdrawing. The official explanation was that he was pursuing entrepreneurial opportunities, which was how the family framed it publicly. The people closer to the situation used different language. He was 23 when he founded his first venture, a boutique event management company that threw parties for wealthy young people in major cities. It wasn't a serious business. It had the structure of a business, the branding of a business, a website and a publicist, and a carefully curated social media presence. But the revenue was largely his father's money, cycling through a company that existed mostly to justify Dominic's lifestyle. 3 years in, the company owed money to vendors, to venues, to a catering firm whose owner had extended credit based on the Harwell name. And that's where the story that ended up in court actually begins. The catering company was called Meridian Fine Events. It had been founded 14 years earlier by a woman named Carmen Ruiz, who had started it with her sister and a catering truck and built it into a legitimate mid-sized operation with a staff of 31 full-time employees. Carmen Ruiz was not a wealthy woman. She was a working businesswoman who had spent 14 years in an industry that runs on thin margins, reputation, and relationships. She had extended credit to Dominic Harwell's company across 3 events, totaling slightly over $240,000. Because the Harwell name had made her confident she'd be paid. She wasn't paid. When the invoices went past 90 days, she made contact. She received assurances. When they went past 180 days, she hired an attorney. When Dominic's company stopped returning communication entirely, she filed suit in civil court to recover the debt. The case was assigned to Judge Margaret Calloway. Judge Calloway had been on the bench for 19 years. She was 61 years old. She had the kind of professional presence that comes from 2 decades of watching human beings make decisions under pressure and bear the consequences. A presence that younger attorneys sometimes described as impossible to read until you'd been in her courtroom long enough to understand that she was always reading you. She had a reputation for patience, for precision, and for a particular intolerance of behavior she described, in one recorded interview with a law school publication, as people treating this courtroom like it's beneath them. She was also known for a specific quality that every clerk and bailiff in her courthouse could describe without hesitation. She remembered everything. Dominic Harwell arrived at the first hearing with 2 attorneys, senior partners from one of the city's most expensive civil litigation firms, and an energy that several courtroom observers later described in nearly identical terms. He was dressed expensively. He sat back in his chair at a slight angle that read as deliberate, as though sitting fully upright in a courtroom chair was a posture he'd decided wasn't worth the effort. When Judge Calloway entered and the room rose, he rose a fraction of a second after everyone else. The kind of delay that's too small to call out formally, but too consistent to be accidental. Carmen Ruiz sat at the plaintiff's table in a dark blue suit she had bought specifically for the proceedings. She had a folder in front of her with organized documents, color-coded tabs. She had been preparing for this for months. She sat straight. She paid attention to everything. The first hearing was procedural. Motions, timeline, discovery schedule. Standard. Dominic said nothing. His attorneys spoke. He scrolled briefly on his phone under the defense table, a movement that the bailiff noticed and that Judge Calloway noticed, and that she did not address at that moment. She wrote something down. The discovery process that followed was, by the account of Carmen Ruiz's attorney, a study in deliberate obstruction. Requests for financial records were met with delays. Documents were produced late, incomplete, in formats that required additional requests to interpret. Emails that had been referenced in earlier communications were suddenly unavailable due to a system migration. A deposition of a key financial officer at Dominic's company was rescheduled 4 times. Carmen Ruiz's attorney filed a motion for sanctions related to discovery noncompliance. It was the kind of motion that signals to a judge that one side is playing games. Judge Calloway read it carefully. She granted a portion of it and scheduled a hearing to address the ongoing compliance issues. Dominic attended that hearing. And this is where the story shifts into something different. He had been in the system long enough by then, 6 months of litigation, that whatever initial caution his attorneys might have advised had apparently worn off. He sat at the defense table with the same backward lean. When the hearing began and Judge Calloway addressed the discovery failures directly, asking his lead attorney to explain the timeline of delays, Dominic turned and said something quietly to his second attorney. Not quietly enough. The court reporter heard it. Judge Calloway heard it. He had said, "Can we move this along?" Judge Calloway stopped mid-sentence. She looked at him. She said, in a voice that courtroom observers described as perfectly level, "Mr. Harwell, was there something you wanted to say for the record?" Dominic looked up. Something moved across his face. Not quite surprise, more like mild annoyance at being interrupted from a private thought. He said, "No, Your Honor." She held his gaze for a moment. Then she returned to his attorney and continued. But something had changed in the room. The attorneys on both sides felt it. Carmen Ruiz, sitting at the plaintiff's table, felt it. One of the observers in the gallery, a paralegal from Carmen's attorney's office who was there taking notes, later told me that in that moment, she understood that Judge Calloway had registered Dominic Harwell completely. Not just the discovery violations, not just the legal procedural issues. Him, the posture, the phone, the timing of his rise when she'd entered, the comment, all of it. The case moved toward trial. The evidence, assembled over months of difficult discovery, told a story that was not complicated once you could actually see it. Dominic's company had received the services. The events had been catered. The invoices had been issued correctly. The money had not been paid. In the financial records that were eventually produced, after the sanctions motion and the compliance hearing, there was documentation of significant payments from the company to other vendors during the same period. The company had money. It had chosen not to pay Meridian Fine Events. Carmen Ruiz had 31 employees. During the 8 months she had spent trying to collect the money owed to her, she had been forced to delay capital investments she had planned for expansion. She had taken out a personal line of credit to cover a gap in payroll. Her sister, who was the company's operations director, had worked without a salary for 3 months to help keep the business stable. These were not abstractions. These were real decisions made by real people in response to a real debt that a very wealthy young man had simply decided not to pay. Trial began on a Monday. Carmen Ruiz's attorney presented the case methodically. Documents, timelines, the invoices, the communications, the evidence of financial capacity to pay alongside the failure to do so. It was not a complicated case. It was a straightforward debt that had been made complicated by a 6-month process of obstruction, the cost of which Carmen Ruiz had largely absorbed. Dominic Harwell's attorneys presented an argument that was, by any reasonable assessment, thin. There were questions raised about the quality of some of the catering services. There were suggestions that certain aspects of the events had not met the contracted specifications. These claims had not been raised in any communication during the 8 months between the final invoice and the lawsuit. They had appeared for the first time in the answer to the complaint. Carmen Ruiz's attorney addressed this timing directly during trial. Carmen herself testified. She was measured, specific, and credible. She brought documentation of everything, every event, every service, every communication. The courtroom gallery, which included several of her staff members who had taken time off work to be there, sat in attentive silence during her testimony. Dominic Harwell also testified. And this is the part that people who were in that courtroom have not forgotten. He had been coached, clearly. The opening portion of his testimony was controlled. He answered questions in direct, minimal terms, avoided the body language that had defined his earlier appearances. But cross-examination is a different environment, and Carmen Ruiz's attorney was experienced and had prepared for him specifically. When she asked him to walk through the timeline of communication, specifically when he had first received the invoices and what steps he had taken to either pay or dispute them, his answers became vague. When she pointed out specific dates and asked him to account for them, he said he didn't recall. When she showed him an email from his own company's account, sent during the period when the debt was being ignored, that discussed expenditures on an unrelated marketing campaign, he shifted in his seat. She asked him, "At the time this email was sent, were you aware that Meridian Fine Events had outstanding invoices totaling over $240,000 that your company had not paid?" He said he believed the invoices were under internal review. She asked when the internal review had begun. He didn't recall. She asked who was conducting it. He didn't recall. She asked whether any written record existed of this internal review. He said he wasn't sure. She said, "Mr. Harwell, can you point to a single piece of documentation, a single email, a single memo, a single internal communication that indicates your company was actively reviewing these invoices rather than simply not paying them?" He looked at his attorneys. His lead attorney was expressionless. He said, "I'd have to check with my team." The jury was watching him carefully. Something had been happening throughout his testimony that the attorneys on both sides noticed, and that Judge Calloway, who had been taking notes throughout, certainly noticed. Dominic Harwell, under pressure, had begun to perform a version of himself that was different from the coached version he'd arrived with. Not dramatically, but in the way that people reveal themselves when the performance of composure starts to cost more energy than they have. A slight return of the backward lean. A tone that occasionally, around the edges of certain answers, carried a quality that was very close to contempt. Not for the attorney questioning him, for the process. The smile came during a brief recess. It wasn't a smile directed at anyone in particular. He was standing near the defense table with one of his attorneys, and something was said quietly between them, and Dominic Harwell smiled. The kind of smile that says, "This is taking longer than it should, but it will work out. It always does." Carmen Ruiz was 20 feet away. She saw it. Her attorney saw it. Judge Calloway, who had re-entered the room before the formal return from recess was announced, saw it. The smile was still fading when everyone took their seats, and she called the room back to order. Closing arguments were presented the following morning. Carmen's attorney was direct and careful and grounded every claim in the record. Dominic's attorneys were polished and attempted to reframe the case as a commercial dispute over service quality, a frame that had very little evidentiary foundation by that point, but that was the only frame available to them. Judge Calloway gave the jury their instructions. They deliberated for several hours and returned a verdict in favor of Carmen Ruiz, the full amount of the debt, plus interest, plus a portion of the attorney's fees, which the jury was permitted to award based on the evidence of bad faith non-payment. The total figure was just over $320,000. Dominic Harwell's expression when the verdict was read was the expression of someone who had genuinely not fully believed it was coming. Not shock exactly. Something more like recalibration, like a system rebooting after an input it hadn't accounted for. But the verdict wasn't the end of it, because Judge Calloway had something to say. This is not unusual. Judges sometimes make brief remarks after a civil verdict, particularly in cases where procedural conduct has been an issue. What is unusual is the nature of what she said and the specificity with which she said it, because she had, as I mentioned, been paying attention since the first hearing, since the fractional delay when she'd entered the room, since the phone under the defense table, since, "Can we move this along?" She looked at Dominic Harwell directly, not at his attorneys, at him. She said that the jury had delivered a verdict that was well supported by the evidence in this case, and she intended to make sure it was followed. She said that the conduct of the defense throughout the discovery process had been among the more deliberate examples of procedural obstruction she had seen in 19 years on the bench, and that her earlier sanctions had reflected that assessment. She said she wanted to be direct about something. She said, "Mr. Harwell, 31 people work for the plaintiff. Several of them were in this gallery during this trial. They have families. They draw paychecks. The testimony established that during the period your company declined to pay this debt, those employees' livelihoods were affected in ways that were entirely preventable. I want you to understand that this court sees that, not abstractly, specifically." She paused. She said, "I also want you to understand something about this courtroom. It functions the same for everyone who enters it. It does not function differently based on the amount of money someone's family has, or the reputation of the firms that represent them, or the posture someone adopts while sitting at the defense table. If you appear before me again, in this case or any other, I expect to see the kind of engagement with these proceedings that the seriousness of a court of law demands." The room was absolutely still. Dominic Harwell said nothing. His lead attorney placed a hand briefly on his arm, the kind of touch that communicates, "Do not respond." He didn't. But the smile was gone. Completely. Whatever performance of composure he'd carried through 6 months of litigation, whatever underlying certainty had allowed him to sit back in that chair and scroll his phone and murmur impatiently during hearings, it was absent. He looked, for the first time in all the proceedings, like someone who understood that something real had just happened. Carmen Ruiz exhaled slowly. Her sister, sitting beside her, reached over and held her hand. The judgment was entered that afternoon. Payment was ordered within 60 days. Dominic Harwell's attorneys filed a notice of intent to appeal, which is standard practice, and which Judge Calloway's meticulous management of the proceedings had made very difficult to sustain on any meaningful grounds. The appeal was not successful. Payment was made. I've thought about this case not because it's the most dramatic story I've encountered. It isn't. No one went to prison. No one's life was destroyed. By the standards of courtroom drama, it's a civil debt collection case that ended the way it should have ended, which is almost the definition of unremarkable. But that's exactly why it stays with me. Because the most corrosive thing that entitlement does in courtrooms, in businesses, in families, in institutions, is not the dramatic harm. It's the quiet, accumulated harm of assuming that the rules are more flexible for you than for everyone else. That delays and obstruction and ignored invoices are minor inconveniences rather than choices with real consequences for real people. That the smile you allow yourself in the corner of a courtroom during a recess is a private moment rather than a statement about what you believe. Dominic Harwell was not a villain in the storybook sense. He was something more ordinary and more insidious. A young man who had grown up inside a system of protection so complete that accountability had never become real to him. Not abstract, real. The kind of real that Carmen Ruiz and her 31 employees had been living with for 8 months while he reviewed his options. Judge Calloway understood something that the most effective people in positions of authority always understand. Accountability isn't about punishment. It's about making reality legible to someone who has been insulated from it. Her remarks after the verdict weren't a lecture. They were a mirror. She held it up and made him look into it in a room full of people, on the record, with the court reporter's transcript capturing every word. That's a different kind of consequence than a financial judgment. Money, at the level of the Harwell family, is recoverable. $320,000 is a rounding error in a $3 billion operation. Richard Harwell, for all the public silence he maintained throughout the proceedings, could have written that check himself before lunch. What isn't recoverable, what Judge Calloway made certain was on the public record and in the professional memory of every attorney in that room, is the courtroom's assessment of your character. The documented finding that you obstructed discovery, the sanctions, the verdict, the judge's remarks. These things exist in case records. They can be found, they can be cited. They constitute a history. That history belongs to Dominic Harwell now. He carries it. Carmen Ruiz took the judgment payment and invested a portion of it in the expansion she had been planning before the debt forced her to put it on hold. She hired 4 additional staff members in the following year. Her sister resumed her full salary. Meridian Fine Events is still operating. She gave one brief interview to a trade publication for the catering industry several months after the case concluded. She didn't talk much about the verdict. What she said, in the part of the interview that I've returned to more than once, was this. She said that the hardest part of the whole experience wasn't the money, though the money was serious and the strain was real. The hardest part was the period in the middle, the months of delays and ignored calls and rescheduled depositions, when she genuinely wasn't sure whether the system was going to work for someone like her. She said she'd heard a lot of stories over 14 years in business about how things go when one side has unlimited resources for litigation and the other doesn't. She'd heard enough of those stories that she had prepared herself, privately, for the possibility that this might be one of them. That she might spend everything she had fighting this and still lose. She said that when Judge Calloway spoke after the verdict, when she said the court sees 31 people, not abstractly, specifically, Carmen Ruiz felt something she hadn't expected to feel in a courtroom. She felt seen, that word, seen. It sounds simple. It isn't. In a legal system that processes enormous volumes of human conflict and translates it into motions and exhibits and procedural timelines, feeling seen as a human being, not just as a plaintiff, not just as a case number, is not guaranteed. It's not even common. It happened in this case because one judge paid attention, because she wrote things down, because she understood that the posture at the defense table and the delay in rising and the phone under the table and the comment during the hearing were all part of the same story. The story of a person who had never been made to take something seriously before. And she decided that in her courtroom, on her watch, that story was going to end differently. There's a reason people who work in and around courts talk about the importance of what they sometimes call the culture of a courtroom. It's not a formal legal concept. You won't find it in a statute or a procedural code. But every attorney who has practiced in multiple courts understands it intuitively. Different courtrooms have different cultures. Some are efficient but cold. Cases are processed. Outcomes are reached. People leave feeling like they passed through a machine. Some are chaotic, where procedure is inconsistent and outcomes feel arbitrary. And then there are courtrooms where something more is present, where the judge has established, through years of consistent conduct, that the room stands for something, that the process means something, that the people who enter it will be engaged with seriously, regardless of who they are or who their family is. Judge Calloway had spent 19 years building that culture in her courtroom. Dominic Harwell walked into it believing it would bend for him. It didn't bend. The last thing I want to say about this case is the thing that's hardest to articulate but feels most important to me after spending time with the details of it. We talk about justice as though it's a single event, a verdict, a sentence, a moment. And those moments matter enormously. But justice is also cumulative. It's the court reporter's transcript that captures every word. It's the bailiff who notices the phone. It's the paralegal in the gallery who takes notes. It's the judge who writes things down in the first hearing and remembers them in the last one. It's Carmen Ruiz's attorney who was in the room for every deposition and every rescheduled meeting and kept the documentation organized and the timeline clear. It's Carmen Ruiz herself who sat straight at the plaintiff's table with her color-coded tabs and her dark blue suit and her 14 years of doing things the right way, and who decided that the right way was still worth fighting for. Justice, when it works, and it doesn't always work, and we should be honest about that, is rarely a single act of heroism. It's an accumulation of smaller acts of integrity. Decisions to pay attention, decisions to write it down, decisions to stand up and say, on the record, that what is happening in this room is not acceptable. And sometimes, on the right day, in the right courtroom, with the right judge, all of those small decisions add up to something that feels undeniably and completely like fairness. Dominic Harwell left that courthouse without the smirk he'd arrived with. Carmen Ruiz left with something she'd spent 8 months fighting for. And somewhere in the record of Crestfield County's civil court, on a Tuesday afternoon in a courtroom where everyone who entered rose when they were supposed to, Judge Margaret Calloway closed the file.